Hi, my name is Arati Ganeshan, and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2021-2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas & Co. is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. Today, we have Kartik Agarwal with us. Kartik is a graduate of the National Law University, Jodhpur, and is presently practicing law before the Rajasthan High Court and the Supreme Court. He holds a specialization in constitutional law from the National Law University, Jodhpur, and actively contributes to the scholarship on constitutional law and public policy. I am delighted to have you here, Kartik, and I look forward to hearing about your research on intermediary liability regimes in India and across the world.
Thank you so much, Aarti, for such a generous introduction. So I would like to share my screen before I begin with the presentation so that it's become easier for the audience to get to walk along with me. So social media intermediaries. So in this presentation, I will be dealing with the social media intermediaries and the regulations around it. Social media intermediaries have assumed a very significant space in our daily life, so much so that we can hardly assume any part of our activity, be it commercial activity or our personal activity, without using any social media platform. However, to the flip side of it, in the last couple of years, various incidences have come to the fore, including Capitol Hill violence in the US, Delhi riots, in 2020 in India, and Republic Day violence in India. And these incidences have highlighted that how the social media intermediaries carries the potential to be used as a platform to peddle fake news and misinformation. Alongside that, these instances have also brought to the fore the wide discretionary powers holds and enjoyed by the social media intermediaries in order to determine validity of the speech. In the wake of these incidences, the government of India attempted to regulate the functioning of social media intermediaries in India, and to that effect, they have introduced the IT rules in 2021, which was subsequently followed by a recommendation made by the Joint Parliamentary Committee on Data Protection Bill, which has recommended to classify social media intermediaries as publishers. During the course of this presentation, I will discuss that if this step is a step in right direction or not, and can this be seen as an effective remedy to the question that we are grappling for such a long period of time. So before moving on to discuss whether a recommendation, whether the recommendation to classify social media intermediaries as publisher is a step in right direction or not, it is imperative for us to have an understanding of the stance taken by certain jurisdictions across the world on the issue at hand. And then we will discuss, and then I will subsequently discuss the Indian position on the issue. And then in light of that, I will proceed on to discuss the recommendation and my take on the recommendations. So the countries across the world have adopted varied approach, have taken varied stance towards regulation of social media intermediaries. Countries like US have adopted a very liberal approach towards regulation of social media intermediaries. USA provides almost complete immunity to the social media intermediaries for any third-party content posted on their platform. The only obligation that the social media intermediaries have is to observe due diligence requirement, wherein they need to take down or take action against the content, against the unlawful content which has been brought to their notice. Interestingly, even the social media intermediaries even enjoys immunity when it comes to any action taken under the First Amendment, which guarantees freedom of speech and expression to the citizens in the US. Because And the primary reason for that being that First Amendment, which forms a part of the Constitution, can only be enforced against state and its instrumentalities. However, the social media intermediaries, which includes private actors such as Facebook, Instagram, Twitter, they are completely out of the ambit of state and its intermediaries, and consequently, they are immune from no action can be taken against them under the First Amendment. To the contrary, EU has taken the jurisdiction under European Union have adopted a very progressive stance towards regulation of social media intermediaries. Countries such as France and Germany, they have adopted stricter measures to regulate the functioning of social media intermediaries. Germany has introduced a law named Network Enforcement Act in 2017 to regulate the functioning of social media intermediaries. The law laid down guidelines towards regulation of social media intermediaries, and alongside that, it also made a provision for imposition of huge monetary fines on social media intermediaries in case they fails to comply with the guidelines. And the fines were so high that to the tune of up to $50 million, 50 million euros. But the law introduced to regulate the intermediaries drew a lot of criticism for being vague and overbroad in nature. The law provided for taking down of content which are manifestly unlawful and unlawful in nature. However, the law itself fails to define what actually manifestly unlawful and unlawful means and what are its contours. And therefore, consequently, it rests a wide discretionary power in the hands of intermediaries to determine for themselves what does manifestly unlawful and unlawful means. Therefore, the whole purpose behind an introduction of such law has not gained any fruition, has not come to fruition in the Germany. A very similar stance as to Germany has been adopted by France, and they have also introduced a law which is called AVIA law on the lines of Germany to regulate intermediaries. However, the law meted out with a different fate in France, and it had many provisions of the law has been declared to be unconstitutional by the court. Primarily, two reasons have been cited by the court while declaring its provisions to be unconstitutional in nature. First one, and most importantly, being that the process of determining validity of content has been rested solely in the hands of social media intermediaries without involvement of any judge or judicial mind in the process, which means that the rights as important as freedom of speech and expression has been left completely at the mercy of social media intermediaries, and it was left altogether on the intermediaries to determine which content is valid and which is not. Secondly, the provision for hefty fines for the intermediaries in case they fail to comply with the guidelines of the law may result in over censorship of content, because in order to avoid being penalized with such hefty fines, the intermediaries may try to take down even lawful content in the garb of unlawful content, which may consequently infringe upon the fundamental right of speech and expression of citizens, and will sweep even the legitimate expression of theirs from the social media intermediaries. Now, moving back to the Indian jurisprudence on the issue. With the introduction, as I've already discussed, that in order to tighten its grip over functioning of intermediaries, IT rules have been introduced by the government in 2021. These laws provided for certain guidelines for intermediaries. However, the guidelines were not sufficient to completely regulate the functioning of intermediaries. And the primary reason for that being that the law was very narrowly drafted, so much so that it even fails to expound on certain key terms such as incitement to offense and racially and ethnically objectionable content, which forms the ethos of hate speech, and which forms the cardinal principle for the intermediaries to take down any content from its platform. And therefore, since it failed to provide a detailed guidelines for regulating the intermediaries, it has again resulted. It has again came to the same result, wherein it has rested wide discretionary powers in the hands of social media intermediaries. Now coming on to the recommendation made by the JPC, which is Joint Parliamentary Committee, to classify uh, social media intermediaries as publishers. According to me, the recommendation is not a step in right direction, and it's not feasible for India, particularly to adopt such a recommendation. And I say this for a multiple reasons, which I will discuss in due course. Social media intermediaries, social media intermediaries deals with a huge quantum of content which is posted on their platform on a daily basis, and the review process of the content on these platforms takes place by way of content moderation exercise, which comes into which basically relies on artificial intelligence with a negligible and very small contribution, with a very small element of human contribution in the process. And therefore the social media intermediaries cannot be equated, and they cannot be placed on the same pedestal as publishers or the print media particularly. To expound it well, expound it further, uh, I would like to take an example. I would like to draw a parallel between social media intermediaries and newspapers, which is a part of print media and is presently classified as publisher under the Indian legal regime. Uh, so when a when a content or any news article is published in a newspaper, it goes through a very strict scrutiny, and a review process is carried out by the editorial team of the newspaper before it is finally published in the newspaper. And that's the primary reason that that a presumption is drawn that in case any objectionable content or any unlawful content is published in the newspaper, then the publisher of the newspaper and the editor of the publisher should be held responsible, as they were very well aware of the content of the information published in the newspaper, and despite being aware of the unlawful and objectionable content, they have not taken any step to stop its publication in the newspaper. And that's why criminal liability is civil, and that's why the Press and Books Registration Act 1867 in India provides for both civil and criminal liability for the editor of the newspaper. However, when it comes to the intermediaries, the process of reviewing content is completely different. As I've already discussed, that the intermediaries relies on content moderation policies which heavily relies upon artificial intelligence to moderate the content. Interestingly, the content moderation activity comes into play when an information is actually put up and posted on the platform. For instance, if an Instagram user is putting up is posting a video on its Instagram channel along with a long caption, then the content moderation of that uh, particular post will take place only when the content is made live and it is actually published on the handle of that particular user. Which means there is no review mechanism for an information before its publication by the social media intermediaries, and therefore it would be preposterous to classify them as publisher and to fasten civil and criminal liability on them by classifying them as publisher. Further, an important distinction between them is that under the Press and Registration of Books Act, an editor of a newspaper is considered to be its publisher, and that's why as a result, civil and criminal liability is provided to be imposed on them in case any objectionable content is found in the newspaper. However, such liability cannot be imposed in case of intermediaries, because there is no particular individual who is involved in the content moderation process as the process takes place through artificial intelligence. And it's a trite law that mens rea is a quintessential requirement while for imposing any criminal liability on an individual. And therefore, the requirement of mens rea cannot be satisfied in case of intermediaries, and therefore it would be preposterous to uh, to classify intermediaries as publishers and to impose on them both civil and criminal liability under the Press and Registration of Books Act, which presently regulate publishers in India. Further, classifying intermediaries as publishers will also result in over removal of content, as the apprehensions expressed by the court in France over the new AVA law that was introduced in France would also come true for India as well, as in order to avoid as in order to avoid such liability, the intermediaries would try to take down even lawful content in the garb of unlawful content, which would result in over removal of content. Lastly, the recommendation has also failed to establish for any judicial recourse against the social media intermediaries. Presently, under the IT rules 2021, under the IT rules 2021, a provision is made for the intermediaries to appoint a grievance redressal officer who shall be an employee of the respective intermediaries and who shall be responsible to resolve the grievances raised by any user against any act of the intermediaries. However, that measure is itself insufficient, as as it is a trite law that no one should be a judge in its own cause, and when an employee of that respective intermediary will be entrusted with the responsibility to take action against to deal with the grievance which is raised against that particular intermediaries of whom that respective officer is an employee of, then the user cannot expect him to come out with an impartial result while dealing with that grievance. And that lacuna has not been dealt by the recommendation, and it has failed to provide for any additional judicial recourse to the users against arbitrary actions of intermediaries. So moving on to the last bit of presentation and the concluding part of the presentation, I shall be making some, according to me, some measures can be adopted by the government to get over or to plug the gaps which I have highlighted in the previous part of the presentation. After my research, I have realized that the quantum of data which the intermediaries are dealing with on a daily basis is so huge that it's almost impossible, next to impossible, for the government to completely take away the discretionary part of the intermediaries to determine validity of content. And therefore, I believe our focus should not be on taking away the discretion of intermediaries, but it should be to limit the discretionary power of the intermediaries to so that they can exercise their limited discretion within the set of detailed guidelines provided to regulate their functioning. And therefore, I propose that there is that the need of the hour for India particularly is that a separate legislation should be introduced by the parliament to regulate the functioning of social media intermediaries. Along with limiting the discretionary power, the detailed guidelines will also help in providing for guidelines which will cut across the community guidelines of respective intermediaries and will put in place a uniform set of guidelines which will regulate the functioning of all the intermediaries. Presently, what is happening is every intermediary has got its own set of guidelines under its community standards, and they are guided by those respective community guidelines only. And therefore, and that's why, because of these varying and the community guidelines of these intermediaries varies from each other, and therefore it become very difficult for users to expect a uniform action on the part of intermediaries when any grievance is raised, or to any uniform response of the intermediaries towards the content posted by that respective user. So that will also be taken care of when a separate guidelines will be introduced to deal with uh, all the intermediaries. Also, alongside this, I believe uh, now you guys must be having a question in your mind that does the government is actually under an obligation to uh, to restrict such intrusion by private actors in the fundamental rights of the citizens of India, because it is presently a conception presently a conception that fundamental rights are enforceable only against state, and the state should restrict itself from intruding in any fundamental right of its citizens. So this gives rise to a question that alongside the government, that is the government also responsible to come out with a law to restrict activities of of any private agency to so that it can avoid intrusion into the fundamental rights of its citizens. The answer to it is yes. The government is under a positive obligation to save any intrusion into its uh, to save any intrusion into the fundamental rights of its citizens, even by a private actor. And this position and this positions came to be changed under the Indian jurisprudence. Firstly, in the case of K.S. Puttaswamy versus Union of India, wherein the government, wherein the court held right to privacy to be the fundamental right of India, and this position has subsequently and the position of positive obligation of the state to save freedom of expression of its citizens have been subsequently held by the Supreme Court in its subsequent decisions. Also, and as I've already discussed, that there is a need uh, for making a provision by the government to provide for judicial remedy against the action of intermediaries. I won't expound much on this issue because after I have submitted my paper, very recently an amendment has been made by the government wherein they have provided for setting up of appellate grievance redressal body, wherein the decision of grievance redressal officer, which is uh, which is appointed under the IT rules, can be challenged. So I won't expound on it much, as it has been to an extent has been taken care of by the government. So with this, I just hope that the government will fulfill its positive obligation to regulate the functioning of social media intermediaries, and it will soon in the come out with specific laws to regulate the functioning of social media intermediaries in the upcoming budget session. Thank you.
Thanks so much for that, Kartik. You can stop sharing your screen now. So this is a topic that definitely at our organization we're always interested about. It's also something that always comes up because the number of cases of these sort of violent things happening as a result of the content online, it just seems to increase every day. So there is a huge need to have this conversation. But I just sort of had a question in terms of the way we're kind of looking at it now. Publishers are just like platforms are assumed to be just hosting third-party content. And that's also the impression I got with some of the points that you made, that, they're not doing enough to monitor other people's, words on their platform. But we've also seen in the US, especially in recent cases like Gonzalez versus Google at the US Supreme Court, where people are coming forward and saying, my child died because Google actively recommended this terrorist attack video to a terrorist who then went and killed my child. Yes, the terrorist did the crime, but Google abetted it by having an algorithm that recommended it. So I would be interested to know, essentially, what is the stance? Are safe harbor regimes evolving to kind of address this question of algorithmic accountability? Because that is a different thing. That's not a third party thing. That's the platform's own technology making that decision. And also in India, what has the position been? Is there a position? Is it still developing? I'd love to know.
Aarti, that's a very interesting question regarding this issue. The recommendation made by the algorithm of these intermediaries, that is purely guided by the monetary or the fiscal benefits of the intermediaries. And this is, and if the readers will view, if the listeners will have a read to my paper in detail, I have specifically pointed out that why there is a need for the government to lay down the guidelines instead of leaving it on the intermediaries themselves to to come up with self-regulating guidelines as they have done in the as they are presently doing for themselves, because their actions are completely guided by their own monetary benefits. So that's the reason that why the government is required to come up with detailed guidelines to deal with the same. And if we talk about and as you have already said that, and you have said it for yourself, that although the terrorist has done the demeanor, has performed the misdemeanor, but it's the Google's responsibility as well, as it has recommended it to the uh, to the to the user that they should view that particular content. So as of now, we don't have any mechanism in place through which we can regulate its functioning. But hopefully, we are moving in that direction where soon the government will come up with laws uh, to deal such to deal with such actions of the social media intermediaries.
Right. So what you're essentially saying is right now companies aren't being following their own rules, and either way they're motivated by profits, especially when you're looking at these algorithms. Fair enough. And just again to like zoom out a bit. So you'd mentioned India's evolution. You had the IT rules. You've had the new versions that came out a few months ago as well. Um, where do you see India going? There are two ways of looking at it, right? You have the US approach, which is sort of a bit of a free for all, by the way you described it, if I understood it correctly. And then you also have, this other extreme where you have, say, something like China, where the government is actively monitoring third-party content and taking active interventions, and platforms are kind of working differently. So not to say that these are two binaries, if everything exists in a gray space, but where do you see India headed? How has India's trajectory when it comes to liability been situated amongst these other countries so far? I know you did sort of allude to that with the comparison between the West and India, but on this larger global spectrum, where do you see it headed?
Uh, Presently, I don't think we are following the footstep of any particular country, and right now we are standing on the crossroads where where we can take the path followed by any one country. Before introduction of the IT rules in 2021, our legal position was very similar to that of USA, as we were also providing the intermediaries with absolute immunity for the content, for any third party content posted on their platform. But since thereon, we have moved ahead towards the path followed by France and Germany, and we have laid down certain guidelines. But still, it would be far-fetched to say that uh, we are following their path, because till now we have not provided for strict we have not adopted such strict measures as it has been done by France and Germany. So I would say that we are standing at the crossroads, and as a statement has recently been made by the law minister, that in the budget session specific regulations will be introduced for regulating intermediaries. So I hope from there on we will choose a path for ourselves, and we will move uh, towards the stance adopted by either the EU, where they have adopted a stricter mechanism, or China, where they are completely overseeing the uh, actions of these intermediaries.
Oh, be careful what you wish for. Uh, well, thank you so much, Kartik, for this. This was super lovely to hear about your work in this sector. If you'd like to watch this video back or read more about Kartik, please do visit our YouTube channel or our website. If you'd also like to listen to more of the work that's been done by the other scholars under this program, do visit our YouTube channel. You can find all the videos over there. Thanks so much for your time, Kartik. Bye-bye.
Thank you so much, Aarti.